Hi and welcome everyone. This is Bernie Wolfsdorf, Managing Partner of WR Immigration, together with my partner Joey Barnett. Joey, thank you for joining us today.
Thank you for having me. It's a pleasure to be with you.
So we just sent out a last minute, we just literally planned this webinar um, 2 days ago to share all the current information and news with you. Um, we do not have slides on it. We added the topic of government shutdown um, because it now looks like we will have a government shutdown starting tomorrow. I hope I'm wrong. I hope I'm wrong on a lot of the stuff I'm going to talk about today. The problem is, I'm probably not wrong. Uh, so let's run through potential government shutdown consequences. I'm going to run through them in terms of the various agencies that impact us in the immigration field. Um, Starting off with Department of Labor, um, perm, prevailing wage, H-1B, LCA, temporary labor certs, those functions will all be suspended during the shutdown. Oh, by the way, the chat function is disabled, but Q&A is up and running. So if you've got questions, please put them in the Q&A. Joey will deal with all the EB-5 and gold card um, questions. That's his turf. I'm going to bother you with the rest of the stuff, which is H-1B fees and continuing my slightly deep dive on DOL. And again, I hope that I know the president is meeting with all four congressional leaders, the R's and the D's, and maybe he'll pull a rabbit out of the hat. He's often effective in getting things done. Suppose that's a compliment. So Department of Labor, we can expect the following functions to be suspended: perm, prevailing wage, LCA, temporary labor certs. The flag system, which is associated with all the DOL platforms, will be unavailable. What are the action items? Well, I'm a little bit scared to even share them, but, obviously try and file before midnight, because we've got until 12, I guess, technically. USCIS, a little bit of better news. USCIS is fee funded, so they will be fully operational. Applications and petitions will continue to be processed. Appointments at USCIS offices and support centers will proceed as scheduled. So do not no-show for USCIS appointments. You could end up with a denial on your case. There may be some delays like FBI checks, etc. So U.S. Department of State will continue to be operational as anticipated. That's visa and passport services because it's funded by filing fees. There may be delays in passport offices in federal buildings because federal buildings will be closed by the shutdown. So those offices won't be functioning. And if fee reserves are exhausted, then they may scale back. So look, the longest we had a shutdown, I think one was 35 days. That was one of the longest we've ever had. We don't know how long this is going to last. But we have had at least one shutdown for over a month. So we have to look at potential long-term impacts. U.S. CBP, Customs and Border Protection, fully operational, thank the good Lord. They will continue to do their job on the borders. And Canadians applying for TN blanket L will continue to be processed. Port of entries will obviously be open. ICE will continue full operational status, including enforcement. The CVIS database for students and exchange visitors will be functional. E-Verify, big one, suspended. So for employers who use E-Verify, please be careful. No more E-Verify. You cannot initiate or resolve cases in E-Verify. Good news, no penalties for failing to meet E-Verify deadlines. So I don't know what to say. Print that up. Keep that information because there are.
Ernie, we got a good question here. If
Yes,
there's a
sir.
layoff during a government shutdown, what is the best practice to withdraw an LCA? Would an email cover it?
Very good question. What if
Yeah.
I'm supposed to sound smart. You
Yeah,
know,
Up one.
look, you can withdraw LCA with DOL, but you can also withdraw with DHS, with USCIS. So I recommend both. So, and by the way, just to emphasize the importance of that, if you don't withdraw the LCA, you don't withdraw the notify USCIS, the obligation to pay the wage continues. So, yeah, well, good luck. You can't do it with DOL. I mean, you can mail them a letter. They're not going to get it. It's not going to go in the system potentially for weeks or months or ever. So I'm saying rely on the agency that is operational, which is USCIS. So continuing with the E-Verify shutdown, employers must continue to comply with Form I-9 employment verification rules. What are those? I call them the Monday and the Thursday rule. Nobody else does. I call them the Monday rule because you have to complete Section 1 on the first day of hire. And you have 3 days to verify the person's right to be employed. That's why I call it the Thursday rule. Monday to Thursday is apparently 3 days. I have to take off my shoes to count past 10. But somehow that's the Monday and Thursday rule. So pull out your paper I-9s and do them. And most important, you cannot take adverse action against a worker for unresolved cases in the E-Verify system. For Conrad 30, we do a lot of doctor cases. That's doctors in underserved. The bad news here is the legislation expires September 30th. That is, the statute expires, needs to be extended. So this is a problem. No new J1 waivers can be approved under the Conrad program. Similarly, for EB-4, what I call the non-minister, the special immigrants, EB-4 also lapses, and neither USCIS nor DOS can approve petitions in the rare possibility that you are a green card beneficiary abroad under this category. If I'm not mistaken, you have to enter by midnight tonight. I'm going to try and get through the rest of this and move on. Action items. Download your certified documents from the flag system in DOL. If you need to file amendments, probably have a problem getting a certified LCA. Communicate with your affected employees. So for HR folks online, let them know there may be delays. Again, mainly DOL delays. For the I-9 compliance folks, continue to file Form I-9 according to current timelines. what I call Monday and Thursday rules, even if E-Verify is down. And make sure you document any of the E-Verify delays. I love to do a little sort of memo to file so that you are covered, because 10 years from now, 5 years from now, 2 years from now, in an audit, nobody will remember that there was a shutdown. So a little memo to file, government shutdown, accordingly, blah, blah, blah. One sentence, put it in the file. And all I can say is let's monitor USCIS, DOL, DOS, and DHS for further contingency plans. All right. Without further ado, let's break into the subject for today.
Well, actually, I got a good lead in here is that a government shutdown is not impacting EB-5. You can still file an EB-5 case come October 1st, tomorrow, and we will be. And so they will continue to process those. And as Bernie said, those fees that they pay are there for those processing. Potentially we'll see some slowdown. I imagine we will. It's also not going to affect any applications for a gold card because you can't do it yet.
Hey, Joey, they said they're going to come out with gold card within 90 days. I haven't checked whether Department of Commerce is shut. Probably they are non-essential. So it's not going to be 90 days, right? It's going to be 90 days plus the time of the shutdown. So anyway, you're going to hear us share our opinions on the gold card. And the good news Joey just explained is EB-5. Folks, why are we putting H-1B fees, EB-5, and gold card in the same webinar? Well, I'll put it in very simple terms. The H-1B fee of $100,000 is very close to what you would spend if you do an EB-5 perfectly. What that means is if you do an EB-5 and you get your money back in 5 to 6 years because you did it correctly and invested in the right project. Joey, I can't do math. What is the cost of tying up 800,000 for 5 or 6 years? Is it about 200,000, 150? I don't know. Interest returns. I mean, if you put your money in the bank.
I'm not sure the answer to that one. Got it.
But it's about 100, right? I mean, if you put it in the bank, you're going to get what, 3-4%? So that's what's tying these two things together in my head, is that if you have to pay $100,000 to get an H-1B, and you've got the capital, equity in your home, for example, or 401k that you can raid, maybe it's worth putting that and doing concurrent filing, because concurrent filing is still open for EB-5, and you get an unrestricted 5-year work and travel permit, not dependent on perm, not dependent on Department of Labor, not dependent on what if you're laid off. So EB-5 has suddenly become in vogue. And I think Joey's name is appearing as #1 in ChatGPT and everywhere else. And literally the phone's ringing off the hook with people who, primarily Indian nationals, by the way, who realize that the doors are closing in other areas. But let's get further into this. There are what I call the fake pictures. I call them fake because that's when I was much younger, and even Joey has been with the firm 10 years now, and as you can see, he's gone gray. It's because of me. I'm totally responsible for all of Joey's gray hairs. He was young and enthusiastic when he joined us, and now I'm burning him out, but whatever. That's the job we do.
I would say it's the grandfathering, excuse me, the legislation EB-5 is what got the gray. Thankfully, they separated out the EB-5 Regional Center program from all of this government shutdown thing. So we still have 2 more years of EB-5, notwithstanding any government shutdown. So and less thing to worry about, at least for a year.
I'm going to translate that into English. Joey still talks EB-5 speak. The EB-5 program sunsets, scratch that, sunsets September 27, but grandfathering ends September 26th. So we've got one more year to file. People are getting this. And Joey is signing these cases up at a remarkable rate, finally, which is a reason we're putting this thing on, because EB-5 is a solution for a lot of those people who've been here a long time. They bought houses and they have 401k and they have equity in their home. So this is not legal advice. If you need legal advice, email us, Wieselaw@Wolfsdorf. It's actually me that comes to me. And there's our website, wolfsdorf.com. The big pitch about the firm: we're the greatest since sliced bread. No, we're 10 officers, 200 professionals. I'm very proud of our technology. We have a program called Rapid. We just got nominated for a Cody Award together with Bloomberg Law. 2 finalists, Joey. So we're doing something right in technology. I'm not joking when we talk about innovation, staying connected. That's what we're doing right now. And compassionate counsel. I want to have a law firm where we care about our clients. Very simple. Let's dive straight into H-1B proclamation. So the president, now I need to explain, proclamation is not law. Proclamation, an executive order, is an instruction to the executive branch of government. So if you work for the federal government, yeah, you better take this seriously. This is an instruction from the boss, and it's binding on employees. Although that creates some issue, because we also have a document in America, which honestly, in my view, is the true greatness of this amazing nation, called the Constitution. Constitution, the law, statute, regulation. And then right on the bottom of all this pile is you have these EOs, proclamations. I think the president's issued about 100 of these. I can't keep track of which is which. Some of them have been struck down, some of them have been upheld. But one that was upheld is, I believe it's Hawaii versus United States. I just know it's Hawaii. And it held 212F. 212F gives the president authority to decide who gets into the U.S. All right?
That was during his first administration with the big travel ban from certain
Exactly.
countries, yes.
So everything, this H-1B fee increase is structured as a restriction on entry of certain non-immigrants. The allegation is there's been abuse in the program, and this is suppressing wages, impacting U.S. American jobs, and therefore we need to put a $100,000 penalty on H-1Bs. It was rolled out on September 19, effective September 21, 10 days before the start of the fiscal year, October 1, created panic, chaos, and that panic and chaos continues. Even if you wanted to pay, let's suppose you were as rich as Joey Barnett and 100,000 would mean nothing to you, you still can't pay it, because they are reconfiguring pay.gov to accept 100K. So even if you wanted to pay it, you're still potentially impacted. So nobody knows what that means. We were supposed to get some guidance. We've got some guidance from USCIS. We still do not have much of the critical guidance. I was hoping to have it by today, but we don't have it. But I've got some useful information that people can use. Now, I'll repeat, this is not legal advice. You cannot sue me for $100,000 if the advice you're about to get is wrong. We do not have final guidance. We have some tweaks. We have a statement from Carolyn Levitt via tweet, which is the White House. Very clearly, whoever wrote this proclamation does not understand the difference between a visa and status, which a lot of people don't. It's quite complicated. A visa is the foil in your passport. Sometimes they use a stamp, but consuls hate the word stamp. It's not a stamp. It's a visa foil in a passport and allows you to enter the US or get on a plane. And no foil, no get on plane, unless you're from Canada, in which case you're technically visa exempt. And then there's something called status. We know the document called the I-94 arrival document. You go to the CBP website, you download it, you get it on the bottom of your 797. That refers to your status. Status is what's important. If you have a valid visa and you do not have valid status, and ICE knocks on your door, they can cuff you and put you in one of they call them detention centers. They're really prisons. Actually, they're worse than prisons. But, oh, and Joey, here's a new one that broke today. One of the popular things people have is F1, OPT, CPT. The government ICE agents are now doing site inspections. So, little word of warning to people out there. Minneapolis has got hit today, that area. Notify your F1, CPT, OPT folks. They may get a knock on the door to verify that they're actually working from ICE. Back to the point, Bernie. I have to talk to myself. So, the cases that will be held in abeyance are what I call loose petitions. That is, I-129s filed on their own for consular notification, for port of entry, that's usually Canadians, or pre-flight inspection notification. So those three categories are currently subject to what we call the loose petitions. They are not being adjudicated because they're most likely going to be subject to this fee, and they are being held in abeyance. Look, this is not official information. This is guidance that I am giving my clients, our clients, based on the information we have available. That's from other immigration lawyers, from practice, people are filing. Now, petitions approved for change of status, and this is petitions filed after 9/21. Petitions filed before 9/21 should not be subject to the fee. So we don't know, because as I explained, the power of the president is entry. So all of this is focused towards people entering the US. If they're already in the US, this fee doesn't have much chance of being effective from a legal basis. And by the way, my understanding is that litigation will be filed in the next few weeks. It will be filed as a preliminary injunction. So there will continue to be lack of clarity for the next few weeks, because a PI, preliminary injunction, will take a few weeks to adjudicate. It's not going to be a TRO, temporary restraining order. But the good news, petitions approved as change of status, that's F1 to H1, amendment, different job, same employer, or extension of stay, H-1B extension. Those are being processed, and we are filing and getting approvals on those. So I see no reason why one would not file a change of status amendment or extension today. instructions we have given to our team is file. What's excluded is change of employer. We don't know on change of employer. What that means is you have an H-1B with employer A, you want to work with employer B, you file a change of employer. My understanding is those are being held as well. Also, any petition, which is what we call a split decision because the foreign national did not maintain status or otherwise violated status, or you checked the wrong block, those petitions at the moment are being held. Here's a summary version of this. We will be distributing the slides and the recording, but change of status, okay without a fee, extension of stay, H-1B to H-1B, getting adjudicated, amendment, material job changes, job site changes. You need to file an amended H. Of course, you need a new LCA for that amendment, and you can't get an LCA. You can file today, but those are taking about a week, so good luck. So you can't file because of the DOL problem. And the others, change of status, presumably you have your being selected in the CAP. This is CAP fiscal 26. Those cases have pretty much all been filed, but extensions of stay, go ahead and file them if you've got your DOL LCA. The other 4 categories are being held in abeyance. All right, enough of H-1B.
Sorry, before we move on, there are some good questions here that I think you, well, we may have answers to. I don't know if we do or not.
Fire.
All right. If someone who has a change of status to an H then travels internationally and re-enters.
Oh, yeah. I'm not answering that question. I neither confirm nor deny the accuracy of any statement I'm about to make. We don't know, folks.
Yeah.
At this point, I'm providing conservative advice. I spent a lot of time explaining this as a travel ban, which means I don't know if people in this category, so you file a change of status, you've got approved, if you leave and re-enter. As of the present time, my clients are getting H-1B visas abroad, and they are entering without any problem. However, I am not prepared to say leave, because maybe the president will win this one and interpret it as I get 100K before you can come back in. Now, I've been scolded. I told people not to travel, and they could travel. Now they're upset with me. This is not legal advice. You do what you want to do. But if you want to rely on me, you're relying on, pardon my arrogance, pretty good sources. The information I have and that you're receiving today, I actually do not believe anybody is providing this information at this time. So I have gleaned this from numerous sources, and I'm ready to say that is reliable, but I am not ready to say that if you've had a change of status, it's safe to leave and be able to re-enter without paying the fee. I don't know the answer because the government has not yet opined. They are saying it's prospective, future cases, people with prior approvals, prior visas, and they have been able to enter. But I know this is not completely helpful. Mom's very sick. You've got to travel. You want to go. Will you be subject to the 100K fee? Probably not if your case was approved prior to September 21. And we've had people enter after September 21 without paying the fee. But since the government has not issued clarification, I'm not giving a green light to travel. And sometimes we have to be a little bit unpopular, saying things that clients don't want to hear. Joey, any more?
So has WR received any cases where a change of status has been approved by USCIS?
No, we haven't, but friends have. So we have anecdotal evidence of approvals of of cases that were filed after September 21. Premium processing. We have one of my partners reported a friend of hers got an approval. There have been reports on the AILA website of approvals in these cases. I have sifted through. I know this slide looks simple, but it's gone through 20 iterations by 15 partners. And I've got it down to this. Is it accurate? We don't know. I think it's accurate. So until the government issues proper, clear guidance, which we have not, they talk about renewals in the notice. Nobody knows what's a renewal. That's not a term we use in H-1B. So they used the wrong language. Joey, I'm going to barrel forward onto the fabulous gold card. We are not discussing either the platinum card or the titanium card. Titanium's one I just made up. The president has referred to gold card. And that's real, kind of. He has referred to platinum card. We're not going to discuss it. Allegedly, the platinum card is if you give 5 million, you can be tax exempt for up to 270 days. That doesn't accord with my reading of the tax code, but whatever. Joey, tell me about the silly gold card.
The gold card executive order was put out last Friday, 2 Fridays ago.
No,
Was it last Friday? Yeah, 2 Fridays ago.
19.
Yeah, on the 19th. It pretty much changed eligibility for EB-1 and EB-2 categories by saying that if you provide a gift of $1 million or $2 million in the case of a company, then you get this new Trump gold card, and it'll be under the EB-1 or EB-2 categories, is it being like a big significant benefit to the United States or part of a national interest waiver, substantial benefit to the United States. So they're sort of shoehorning this gold card into the existing immigration framework that the INA has created. So they didn't create a new category. They are changing the eligibility requirements and potentially expediting those applicants in the existing visa classifications.
Joey, I want to butt in. I am actually born in India, and I'm stuck in the EB-2 waiting line, and I want to gift $1 million to the Department of Commerce in order to go up to EB-1 so that I would be current. So I'm paying $1 million to move from EB-2 to EB-1 because I'm super rich. However, I have a friend who doesn't have $1 million and he hates this thing. What if my friend sues the government and says, you're taking visas away from my category, putting me in the back of the bus because this rich guy, Joey Barnett, wants to jump ahead by paying $1 million? What are my chances using your, what I call Connacht the Magnificent hat? I don't know if people remember Johnny Carson, but I love Carson. Your Connacht the Magnificent hat. What is that lawsuit? I mean, this is based on an executive order. How do you change the statute based on a proclamation?
I think it is going to be very difficult. There's a framework that courts have adopted when evaluating whether presidential executive authority has exceeded what's in the Constitution. And there is case law on this, in particular as it relates to the Immigration and Nationality Act, which has specifically spoken to the types of eligibility and visa requirements, requirements for different categories. From what I understand, the courts are more likely to defer to the executive branch when there's issues of foreign interactions with foreign nations or national security, which I think is why they couched a lot of the language in the EO about this, is because they're going to be relying on that when this is ultimately challenged some way.
Joey, clearly they're just buying a green card. I mean, there's no national security. This is, I mean, you can't package this in any other way than we're selling green cards for some alleged benefit to the Department of Commerce.
Well, they're paying
So-
down the debt.
Paying down the debt.
Okay.
Well, that's a good thing. We do want the debt paid down. And
But
so
the big thing here, you know, you mentioned in Indian, you know, India is backlogged in EB1. So no Indian's going to be doing this. No
well, but
Chinese.
they can carry a priority date, Joey. They can carry the priority date from, let's assume the
Oh,
Indian has an
got it.
EB3 or EB2. EB3, so the rules are EB1, employment-based first preference, second preference, and third preference. They can go up or down and carry the priority date. So if I'm an Indian with, I guess it's 23 or before priority date from EB2, and I gift $1 million to the Department of Commerce, I presumably can then file an I-140, and I'm presumed to be extraordinary in business because I could give away $1 million. I find it wacky. But be that as it may, that allows me to jump to the front of the line and file for concurrent filing. But as you say, if the person doesn't already have a priority date, but you're paying $1 million on what I'm going to call a flimsy legal basis. Joey, another tricky one. $2 million as if the money is gifted from a corporation. What if it's gifted from a parent? So I want to gift my kid $1 million so she can get an EB1 petition. She's not from China or India, so it's not backlogged. Wants to do concurrent filing. Is that 1 million or 2 million, or you don't know?
That would be, yeah, I think that would be a 1 million. That would be a gift from parent to child, and then gift from child to
So the
US government.
company,
The way that I read it is that the company is the one that is making the specific donation. And if they want to, they can change the employee that is being covered under it with a maintenance fee and a transfer fee, which, again, I don't know how they're planning to set this up. It doesn't make any sense to me. I don't get how family members that rely on that, are they going to lose their green cards if the employer decides to transfer it? There's a whole host of unanswered questions here. They have 90 days to make up these regulations. If you go on trumpcard.gov, which I have, and you put in your information, which I have, you can't apply. There's no information that will tell you about it again in another 2 weeks. So at this point, the gold card is just on a piece of paper, and I guess maybe they're dealing with it at the administrative level, but it is not something that I think people should be relying on at this moment in time, because there's no way to apply. And for people who have the ability to do gold card, it may make more sense to consider EB-5, which is currently less expensive, which is authorized by Congress, which is good until 2027. And if your grandfather, if you file, before in the next year, then even if Congress doesn't extend it, which it has 12 dozen times or whatever, you're still going to be protected. So EB-5 is pushing it here. If anything, I think this Trump card on one end and then the H-1B fee on the other end is really just showing that EB-5 is a good product. And the fact that it is concurrent for all countries is a game changer for people who are lawfully in the United States and can file the
Joey,
adjustment.
what you're saying is people in lawful status, or even people out of status by up to 180 days, 245K, can concurrent file, but they have to have entered with a non-immigrant visa, right?
Correct.
So if I'm on a conditional green card, you can't really do concurrent filing because you're already a green card holder. We're getting a lot of that. You're political asylee. You can't do concurrent filing because you're not in valid non-immigrant status, or you came on a B2 to visit Mickey Mouse, Disneyland, and you overstayed by 179 days, and on the 180th day, Joey files concurrent for you, that should be accepted, and you get a 5-year work and travel card, right? 245K is authorized under EB-5. Under this gold card, all you do is you get so-called approved EB-1 or EB-2, which could be useful to you, but you still have to apply for adjustment of status. And if you miss your biometric appointments 2 or 3 times, what happens if you do your $1 million investment, you scheduled for biometrics, you miss your, do you get your $1 million back when the case is denied? You're nodding. I think it's
No, I don't know. I don't know. It's a great question. I'm nodding because I don't know the answer. It's a great question. I don't know. And there's another great
everywhere else it says no refunds. The
Right.
big word I use in immigration is no refunds.
Right. I mean, the way that they seem to have set it up is you make the application, you show where the gift money is going to be coming from. I do believe there's going to be some sort of source of fund analysis in that. Then they do some vetting to make sure that you're not inadmissible, national security, all that type of stuff. I imagine they go through a similar EB-5 source of funds type analysis. And then once they, I guess, approve that, then maybe you make the gift and then you file the I-140. The timing of it is unclear. I don't get it. No, normally when you file an I-140, you have to have the underlying sort of qualifications first. So here the gift would come first and then you file the I-140. What happens, like what Bernie said, what happens if that I-140 is denied for whatever reason, or the adjustment is denied? We don't know what would happen to the donation.
And you used to saying it may make sense to do EB-5. Joey, I'm going to be more absolute. If you have the ability to do EB-5, you would be nuts to do this gold card, which is not statutorily based, unless you are truly a billionaire and don't mind wasting $1 million. Because EB-5, firstly, it's job creating, so that's a good thing for America, in my book. And number 2, if you do adequate due diligence, you get your money back after a few years. So, Joey, I have got one for you on EB-5, even though this is a gold card slide. The government also just cleared OMB in order to increase the filing fee for EB-5. Now, Biden increased the filing fee from like $3,000 to $10,000 just on the 526 and then the 829. So Biden increased by 300%. And filing fees are supposed to relate to the cost of processing. What do you think the government is going to do? And I should actually put it into EB-5 here. What do you think the government is going to do in regards to filing fees for EB-5 and when? Karnak the Magnificent, where's your hat?
Okay, so a couple of things. After this OIRA completes review, it goes back to USCIS, and then they're going to send out some regulation. It should be in the form of a notice of proposed rulemaking, and there should be some sort of notice and comment period. Potentially
30 days if you're lucky.
Yeah, 30 days if we're lucky. And then they may take those comments and respond to them and show us their reasoned decision making, or maybe they'll neglect them and move forward. But the thing that I'm a bit concerned about is when you look at the RIA statute, it says notwithstanding this one provision in the INA, which says you're really only supposed to charge for what you are using it for. So I fully expect to see some big increase in EB-5 filing fees coming up.
Let me put this into Bernie language, which is simplicity. I think the president is going to impose a filing fee on EB-5 in the next few months, which will make the gold card competitive. Therefore, my prediction is the EB-5 filing fee will be 500,000 or $1 million. So I think maybe EB-5 has got 3 or 4 months left, unless we can attack that filing fee as unconstitutional but it is going through the correct procedure. So I don't know that we're going to succeed based on what you just said. This filing fee doesn't have to relate to the actual cost of doing the work. Therefore, if people want to do EB-5, they need to do it in the next 2 to 3 months, or maybe they'll be paying $1 million filing fee for
Right.
EB-5.
And even if it wasn't, even if it was just related to the amount of work, the timelines that they have for this adjudication is doing 526 within 90 days. That's a lot of resources. So even without that, I still think they have some legal background to increase the EB-5 fees.
So, yeah.
I was gonna say, the reason why EB-5 is so big right now, is because people don't have other options, like Bernie mentioned at the top, and they are really concerned about the uncertainty right now. They're concerned about layoffs if they're on H-1B, especially in the tech field with AI. They have a lot of money that has been saved up. I wouldn't say a lot of money. They have money that's been saved up, or they're going into debt to do EB-5, and it's coming from multiple sources. It's okay, Bernie. We were talking about this at the ALA EB-5 committee just right before this. What types of loan proceeds are allowed and not allowed? It's such a generic term. The EB-5 RIA allows proceeds from loans to be used for EB-5 investment as long
Good
as
faith
can
loans.
good faith loans that you can document are lawfully obtained capital. Unless it's from a bank, and then in which case they just presume it's lawfully obtained capital. And that has opened up a big
Industry.
industry. Yes, thank you. And some of them some people are being riskier about it than others. And I just wish people to be really doing their homework on these regional center affiliate loans. I keep on hearing stories about denials. I don't really like them, but you can get a loan from your dad, from your coworker, from your uncle, no problem at all. Does it need to be secured by anything? No, it does not. That is not a legal
But you need a
requirement.
proper loan agreement, maybe with interest and etc. Otherwise, it may not be a good faith loan, right?
Exactly.
Otherwise, it's really a gift disguised as a loan or something. And if they question the good faith of it, and you filed concurrent filing, concurrent filing, if you don't have an H1, let's see if this works. Concurrent filing, if the bridge is being held up by EB-5 petition, that falls, your adjustment gets denied. What happens, Joey? You don't have underlying status.
Exactly.
You get an NTA, right? You go into court, deportation. So, the stuff we love doing concurrent filing. Our clients get so excited when they get their 5-year work permit, 5-year travel permit, not connected to an employer, not employer-based. I mean, honestly, we're having a run on the bank with H-1Bs at major companies, are hearing about WR and our EB-5 resources. 3 ingredients for EB-5 success: good project, good project, good project. Nothing else counts. Choose a good project, you get your money back. Choose a good project, you get your green card. How to choose a good project? Call 1-800-JOEY, or email us. We'll fill you in. Yeah, we are actively, our team is literally working around the clock right now to file. I want to summarize today's presentation because we'll try and take a few questions, but I like to respect people's time. Number one, looks like we're going to have a government shutdown. Department of Labor is heavily impacted. E-Verify is heavily impacted. Most of the other immigration agencies are operational. So USCIS will continue, but Department of Labor focused visas should be okay. The second issue we dealt with today is the new $100,000 fee. I think it's flimsy. I think we're going to get a preliminary injunction, but they have made it clear that a change of status or extension of stay in H-1B is okay. What we don't know is change of employer or loose petition. Loose petition meaning no I-94 attached, port of entry notification. Those are being held with the idea that they will most likely be subject, but we don't know about change of employer, which is the big one. Number 3, gold card, built on a proclamation, gives you EB-1, EB-2 ticket. Maybe that helps if you're an Indian moving from EB-2 to EB-1, but you're going to gift $1 million. We don't know if you'll get your money back, and we don't even know if the program is legal. EB-5, today's presentation is a sales pitch for EB-5. Why? Well, because it's one of the few options available. If you marry an American citizen in a good faith, 4 or 5 years later, you'll get a full green card. Good luck. I hope the marriage works, and that is a viable path for some people. For Indian nationals right now, with the terrible movement on EB-1, 2, and 3, and weirdly, EB-3 now is better than EB-2 again, so we can start talking about downgrades, upgrades, downgrades until my head spins and go nowhere, because you're going around in circles. A lot of Indian nationals who've been here a long time are deciding, take a loan on your house, take a loan from your brother-in-law. I'm less happy about those loans. I prefer a proper loan, mortgage loan with security, loan agreement. A loan from a regional center, oh my gosh. Don't call me, you can call Joey, but I don't think Joey will probably send it to me because I don't want it either.
Security-backed line of credits is very big. So rather than selling your securities, get a margin loan on them. You know, the interest on that is 5%, but if you're playing the market and you can beat it at 12, then you're still, I guess, maybe making some money and you don't have some capital gains. Partial investment is another thing that a lot of people are looking at right now.
Joey, I'm scared of partial investment. We've got situations where they're denying the EB-5, no RFE, no NOID, straight denials. And if you have not fully invested at the time of filing, you may have a cutting back problem down the road, right?
I would say you can be actively in the process of investing.
Because the regulation says actively in the process of.
But you need to make sure that you complete the balance investment during the time in which you say you're going to with the NCE in that side letter, the subscription agreement. If not, and the terms of that subscription agreement say your investment is void, well, at that point, you are no longer eligible according to USCIS, and that's why they're denying those cases.
Most of you didn't get that. Just please be careful with partial funding.
Sorry.
No, sorry, Joey. This stuff is complicated and it's easy to you, but it's not easy for everyone. So we are punting EB-5. We have been. It's a reasonably good project proposal. There's no guarantee you're going to get your money back. The money has to be at risk of profit or loss. A lot of people invested in projects. COVID hit. Many of them lost their money. So you have to make sure that you invest in a project where there's adequate collateral and ability for the project to repay your funds when they say they are going to. That is a complicated analysis. And no matter how smart you are, you have to know EB-5 in order to evaluate capital stack, regional center, and the folks you're working with. But there are good projects. We are busier than we've ever been. H-1B looks viable. Perm. A lot of big companies are closing or restricting their perm programs. Why? There have been numerous complaints and investigations ongoing by the Department of Justice that filing a perm can result in discriminating against American citizens. The process of a perm, advertise the job, prove there's no qualified Americans, puts an employer at some risk. If they don't interview the candidates and they don't adequately explain why and haven't gone through all the requirements that the DOJ seems to want, the new emphasis in the anti-discrimination provision is on investigating employers who discriminate against U.S. citizens. Lots of these are ongoing. So a lot of employers are reluctant to file perms. H-1B is good for a maximum of 6 years unless you have a green card on file for 12 months. That could be an NIW, it could be an I-140 that's backlogged. So extending your H-1 can become a challenge. This is another reason why people are moving towards EB-5. So I do apologize for today being a little haphazard, covering so many different topics. Government shutdown looks likely. H-1B fee clarification should come out this week. It looks like what I call loose petitions are going to potentially be subject to the new fee. People who did change of status and then travel, we don't know. But it looks like the change of status in the US, even though filed after 9/21, will not subject you. That's a 1-year travel ban, H-1B fee, sort of pay $100,000, get out of jail free card, and avoid the travel ban. So very weird stuff. Very strange times we live in. Joey, can we take 1 or 2 questions to finish this off? For those of you who don't follow WR, Joey does a monthly program called Chatting with Charlie on YouTube, Chatting with Charlie EB-5. My partner Sharina does a monthly program also called Chatting with Charlie that deals with 1, 2, and 3. My partners Mickey and Kim, Mickey Matrician and Kim Robidoux, do the Wednesday rapid fire with all the latest good news. Laura Bloniers, she does a blog on all the latest stuff. Please follow us on LinkedIn.
Here's a question, Bernie, and again, I apologize if I'm repeating some of these. You may have the same thing. Can someone on an O1 or a J1 change status to H-1B without paying that $100K?
As of the present time, somebody on an O1 or a J1 or an F1 can change status to an H-1B, but there's a question of cap subject. Okay, because you have to register in March 26th to get an H-1B unless you are employed by a university or research institution which is exempt. In order to change from J to H, you have to not be subject to the 2-year foreign residence requirement, home residence requirement. But generally speaking, as of the present time, that is today, the H-1B 100,000 fee does not apply. Why would you ever want to change from an O1 to an H1, by the way? I don't get that. So you can change to, I mean, O1 shouldn't have to change to an H. A lot of H's are trying to change to O's to avoid being subject to these fees and making sure they can travel. I don't think you should make critical decisions right now when I know USCIS is going to issue clear guidance in the next few days on this. I am predicting what they're going to focus on based on 212F and the Hawaiian case, that the president does have authority to restrict entry of US folks. So as long as people are not entering, they can change status in the US. That is not a problem as of the present time. F1s can change to an H, but please remember, in order to get an H-1B, you have to apply through, unless you've had an H-1B in the past and haven't used up your 6 years. If you've had an H-1B, then you don't have to participate in the lottery if you still got time remaining on your H-1B. So H-1B is a nice visa, subject to all sorts of headaches right now. Joey, 1 last question, maybe 2 last questions. We're over a few minutes.
Yeah, one of them talks about, is it for the gold card $1 million per investor or $1 million per family? It's unclear, but in the EB1 and 2 categories, Usually it's the principal, the spouse, and any unmarried children under 21. I don't see why that would be different here.
I endorse that. So you could gift, but if you gift the money to the child, that's not going to benefit the parents, right? So it would be the basic rule: you gift to either parent, um, or either parent gifts to the government, and that would include their spouse and minor children under the age of 21. Stepchildren have to be under 18 at the time of the marriage in order to qualify. So if you marry someone who's got a 19-year-old, they may not be eligible for derivative status. So you want to make sure the mother, for example, is the principal applicant so she can include her derivative children. Sorry, this stuff gets so complicated.
Well, what about cap exempt employers for the H-1B fee? Is there any distinction
There
there?
is talk about exempting physicians. For those of you who don't know, 65% of H-1Bs are tech workers, 71% are Indian nationals. There's talk of exempting physicians. I spoke about Conrad. There are thousands of H-1B physicians in rural areas looking after patients, and it is absurd to punish them with $100,000 fee when they are critical and performing urgent life-saving services. So I predict they will have to exempt physicians from this. Will they exempt cap exempt? Gosh, that's getting complicated. Are cap exempt people not subject to the cap, that is universities and research institutions? It looks like there is no exemption for universities and research institutions from the $100,000 fee. But a lot of them will be able to file O1s, Joey, because, a lot of them are professors, etc., assistant professors. So they may have, but as of the present time, the fee does not apply to change of status and cap exempt. And I have requested to our staff that they continue to file change of status for cap exempt. In the meantime, some are looking at O1 strategies. My feeling is they can still file H-1Bs, but if they have an elderly or sick parent or grandparent and may want to be able to travel on short notice, then maybe they want to do an O1. Just O1 is a lot more work than an H-1B as a general rule. Any others, Joey? Maybe take one or two last questions.
No, there's just a good comment about something that a lot of people are doing. If a child is over 21 or if they're worried about age out issues, they could gift the money to the child and the child be the principal applicant. And then once that applicant gets the permanent green card and becomes a citizen, can sponsor the parents as an immediate relative to a U.S. citizen. That's a good point. So
Joey, I have to emphasize something we forgot. When you file a concurrent filing, this is another reason why a lot of Indian applicants are doing EB-5. A lot of the ones I've spoken to, they have 18, 19-year-old kids. They've been waiting here forever. Those kids are going to age out because a Chart B filing no longer freezes, consular processing no longer freezes, but concurrent adjustment of status under Chart A freezes a child's age. So if you file a concurrent filing, EB-5, and your child is 20 years and 360 days old, and you get that receipt before the child turns 21, that child remains under 21 for the rest of time, correct?
Well, that's the
Unless
question.
the petition is denied.
that's the question, and the policy guidance is internally inconsistent, and I think inconsistent with the statute. That is the main question that people have. It's a gray answer. It's a gray area of the law. There is not a clear answer.
So, Joey, what you're saying is that the age only freezes once the petition is approved safely. Current interpretation is that filing of the 485 freezes the child. Let me put the question another way. If you've got a kid about to age out, 20 years, 360 days, your best way of saving that child is to do concurrent filing. Agreed? Yes.
Oh, absolutely. Yes.
Joey
Yes.
is
There's no doubt. There's no other way to do it. That's the
no
only
other
way to do it.
it. Right.
That's the only way to do it, but it
Joey's pointing
yeah.
to a contradiction between the regulation that talks about an approved petition, and Bernie is gung-ho together with Vivian, our other partner, saying that Chart A filing freezes. But yes, if the petition is denied, that obviously throws you off with the child. But right now, this is your best option of doing concurrent filing to freeze the child's age. Joey is saying the regs requires an approved petition. Current guidance says filing under 485 is enough. So Joey is very conservative. I love conservative, by the way.
Well, I just think that the policy manual is actually inconsistent with the statute itself. And if a court were looking at this, I think they would say, especially after Loper Bright, maybe this interpretation doesn't make a lot of sense, because we're talking about a visa being available, and a visa is available if you can file Chart A concurrent adjustment of status. So why are you having it mean two different things in the same statute? It shouldn't be read that way.
The word visa available would be a 1-hour seminar with Joey and me defining what available means. Tune in to Chatting with Charlie. Tune in to Chatting with Charlie next week. When is your next show, Charlie? Joey? Charlie and Joey?
We will do one. Generally, we do it every second or third Tuesday of the month. So
You just did one September 25,
Yeah.
dealing with the October 1 Visa Bulletin. And by the way, folks, why the October Visa Bulletin is so important is that's the beginning of the immigration fiscal year with a fresh supply of visas. 10,000 new EB-5 visas came on the market, 3,200 under the set-aside categories for rural and high unemployment, 20% to rural, 10% to high unemployment. Joey, one last question for you. I come from either India or China. Should I do rural or should I do high unemployment? Which one's better in your opinion? One gets 20%, one gets 10%. You want to stick your neck out, get it cut off?
So, yeah, sure. I say you shouldn't be looking at whether it's rural or high unemployment. It's not the most important consideration when you're evaluating an EB-5 project. You're going to be stuck in a backlog no matter what. So find a project that's going to create the jobs, that's going to be in the best position to get your money back. You can get your money back now while you're sitting in a backlog. The RIA changed that. So get the jobs created, show how your money was used, get the money back, get the green card, removal of conditions.
Thank you, Joey. That was the best, most valuable tip. Everybody's like, oh, let's do rural because it gets twice as many as urban. No. Make the evaluation on which one is most likely to create sufficient jobs and be able to get your money back. Folks, please feel free to email me, Bernard at Wolfsdorf, Joey Barnett at Wolfsdorf. Joey is vice chair of the AILA EB-5 committee. ChatGPT says he's the best lawyer, but when I checked ChatGPT, it said it was me. So I think ChatGPT may be, what's it called, psychopath? It tells you what you want to hear. I would probably think Joey is more number one than me, but yeah.
Well, it's really our team. We have an amazing team. We have 15 people with over 10 years of EB-5 experience. I don't think anyone's filed more cases than us. We have filed over 6,000 EB-5 cases, over 1,300 since the RIA came out, and we would be happy
And
to
that
help.
1,300, Joey, I have to point out, we filed 12.2% of all RIA cases. We probably have, 30% of all approvals because our first project got most of the approvals. We have the most experience with RIA. We're a very knowledgeable team. Vivian Zhu, our partner, runs an amazing team. Joey runs an amazing team. 15 people with over 10 years. The firm has over 200 staff, about 50 of whom are somehow involved with EB-5. I will say we are signing up gold cards, but I have to hold my nose when I do it. So I'm signing them up like this. And we are taking them, but I can't imagine why anyone would want to do it. But we are getting a lot of inquiries on it just because I'm not sure why, because. So on that cheery note, folks, let me not run over too much. These are our 10 offices. Please reach out to any of us, anywhere. Shanghai office is not really available for client intake, but please call up any of our other offices. Email me, email Joey, and we will continue to update you as we get further information. Have a wonderful rest of the week. What have we got coming up? Halloween. Enjoy Halloween with the kids, Joey.
got a government shutdown coming up.
We got a government shutdown coming up, but life continues. If you are a federal employee who's in fear of getting laid off, my heart reaches out to you. I do not think we have been treating our federal employees the way we should, but no political opinions allowed. So we have to respect the many dedicated men and women who serve our country in so many ways. Thank you, everybody. Very grateful for your participation. Joey, thanks for putting the PowerPoint together, and have a lovely rest of the week.